Hello guys, and welcome back to another episode of my lecture. On today's episode, we are going to start our series of classes on the nature of a confessional statement. And in this particular episode, I will talk about the first rule that you need to know about the nature of a confessional statement. And this is the point where we go to my notes. So the first rule, that's rule 1. Confessional statements are both extrajudicial and intrajudicial admission of guilt, be it verbal or written. That's the case of AMAKA versus the state. A confession can indeed be in writing or in oral, as stated in the case of AROGUNDADE versus the state. In other words, the mere fact that a confession is only oral doesn't mean it carries less weight than that is written, as stated in the case of Jua versus the state and OLUSEGUN OTUFALE versus the state. It doesn't matter whether a confessional statement is made during trial, although a confession made during trial is of greater force than all proof, as stated in the case of NWOSU versus the state. A confession is so potent that even in the event of an improper identification of the defendant, once the court finds his confession was voluntary, he can be convicted based on the confessions, the issue of identification notwithstanding. That is the case of USUNG versus the state. However, for a statement to qualify as a confession, it must be a confession to the offense charged and not of a different offense, as stated in the case of GBADAMOSI versus the state. So, yes, our first rule basically is the fact that when you are talking about a confessional statement can be both oral and written. Some people have this mistaken, belief that, when there is a confessional statement, it must be in writing. It's not all the time that it needs to be in writing. Sometimes an oral confessional statement that is heard by somebody can be testified to in court. So for example, we have the case of AROGUNDADE, which I'm going to use to explain in my next rule. Now in that case, when the accused got to the police station, the accused first confessed to a policeman. Do you understand? Before it was written. Do you understand that? The accused first confessed to a policeman. Now, that means there have been two confessional statements. One was made orally, one was put into writing. Do you understand? So when you go to a police station and all that, and you're asking for the evidence of, your client's confessional statement, and he said, oh, he did not confess in writing, he confessed orally. You're like, oh, he's not going to hold up in court. That's the fantasy, because it's actually going to hold up in court. Do you understand? It just depends on whether during their examination in chief they can give the confession the way the person has said it in the examination in chief in such a way that it is a valid form of evidence. Do you understand? It means that the person that heard it, that means the policeman that they testified to, not any other policeman, because if it's any other policeman, then that will be hearsay, as I've taught you in when I was talking about different types of evidence. It has to be the policeman that was told, that will come to the stand. Do you understand? To then give that confessional statement, the whole thing that happened. It is the policeman who then comes to the stand, testify to the fact that he said all those things. Note that the policeman is not testifying to the truth of what happened, because if he were testifying to the truth of what happened, that's going to be hearsay. He's testifying to the fact that the accused told him. That then is a confessional statement that he is admitting into evidence. Do you understand? He is not saying that what happened is true. He's saying that the accused told him. So you have to make sure, as the lawyer for the accused, you have to make sure that your cross-examination would be to impeach that particular statement, not to get into evidence. Do you understand? Because the moment that statement gets into evidence, then it is a valid statement. So note, according to the series of cases, confessional statement can be both oral and written. Now, not just that, it should also be noted that when there is a confessional statement cannot stand except the person testifies to all the requirements of that offense. So where, for a rape case, for example, somebody is about to testify to raping somebody. Now, what are the elements of rape? The fact that there was penetration, and then secondly, the fact that such penetration was done without consent. Imagine that in a confessional statement, what he said is that I had sex with her. I had sex with her is not confessing to any crime. I had sex with her is only stating that he had sex with her. That is not a crime to have sex with somebody. But when he says that I had sex but she said no, but I continued, that then is rape, and that then would be a confession to the particular crime. Do you understand? So you should understand that as a lawyer, when you are looking at a confessional statement, one of the key ingredients you should look at, the nature of a confessional statement, one of the things you should look at is the fact that that confessional statement must align with the crime that is being charged, that your client is being charged for, and not any other crime. And if it is this one, it must align with all the requirements of the crime. Do you understand that? And also, it is very, very important to note that where somebody has been improperly identified, when you're talking about identification of the accused, where there is a raid and all that, the police usually does something called accused identification, where they put different kinds of people. There is a show glass. I'm very sure if you watch American movies, you would have seen it. And then the victim is in the office but can look through the whole set of people that has been arranged, and then the victim would then be the one to point at the person and say, oh, that's the person I saw, oh, that's the person that did it, and all that. So when there is an improper identification, because there are rules to be followed for identification procedure, where there is an improper identification, even though there is an improper identification but the accused has confessed to the crime, that confession overrides the improper identification, as has been seen in the case of USUNG versus the state. So confessional statement is so potent that once they have it against your client, that your client is likely going to jail, except you are a good lawyer enough to expunge the confessional statement from the proceedings. That is the time that you can then have a proper trial, because when your client has confessed, the scale is like this. Then you have to then balance it up. Balancing it up would mean that you have to expunge that confessional statement from evidence. In short, not even expunge. You shouldn't even let it go in the first place. Do you understand that? In my next class, I will be talking about rule 2 of the nature of a confessional statement. And this class we've talked about rule 1. So I will see you in my next class.